Assalamualaikum warahmatullahi wabarakatuh. This is a lecture for the topic General Defenses in Thoughts. This is actually part 1. This is the second video, continuation of the first video. So for the first video, okay, let me just maximize. Okay, for the first video, we covered some of the cases on top of the meaning, the definition, and also cases. Which involve or revolve around voluntary non-fit injuries, some of the landmark cases. Okay, now we are going to focus on the subtopic of voluntary non-fit injury, which is consent in sport. Consent in sport. Okay, so what's the issue here? Okay, basically we want to discuss whether voluntary non-fit injury (VNFI) can apply against those who are injured in the sport event. So very specific circumstance or situation here. So whenever we talk about sports, okay, sports event or sports activities. Okay, I put it here. So consent to an injury applies when the injury is the type which is inherent, and it happens under normal circumstances of the sport under its rule. So basically, the rule or the defense of not voluntary non-fit injury is applicable whenever the sport, whenever the injury which happens to anyone in sports, doing sports activities, it happened under normal circumstances, and all the person actually, they comply with the rules. Okay, then only the defense could be made applicable or relevant. So this particular defense is available, okay, is applicable to anyone who is involved in such a sport activities. For example, the athletes, the sportsman himself, officials as well, reporters, spectators, and any other person involved, okay, or within that time, or locality, okay, within that particular area, for example. Okay, but from some of the cases, okay, from the case law, the injury may not be consented even if the players observe the rules. So there are some decided cases, okay, which actually explain or show that actually, despite the availability of the defense here, but the court did not accept the defense. So meaning that here the plaintiff can still proceed to get the compensation. So the defense is not available to the defendant. Let's have a look at the case here. Afutu Nati and Clark are reported in 1984. Okay, that's the case. So it is between plaintiff defendant. So defendant was a qualified PE. PE is a physical education, okay, teacher. So he was coaching rugby to a group of 15-year-olds. Okay, if in Malaysia it is in Form 3. Okay, secondary school, but lower secondary school. And then this coach, okay, he was supervising, and he was also the referee, okay. And later he joined in the game, okay, to even up the numbers. So I mean that here, to make sure that the numbers of the both teams were even, okay, to balance the numbers. So he joined as one of the players instead of only supervising or being the referee. And then the coach or the teacher here, he tackle is a movement, okay, in the sport, in football, in rugby, okay. He tackled one of the 15-year-old players, and this student, okay, he fell and seriously injured, okay, and it affected his spine. So serious injury to the spine. So and the student, okay, the parent actually brought the action against the teacher, and the court found that the teacher actually was negligent, and he was in breach of his duty of care. And this is the this is the relevant part of the judgment here. The judge said that, okay, in giving the judgment, or in making the observation, the judge said that it is wrong and a breach of the duty of care, okay, owed to the schoolboys, okay, for a master taking part in the game to have any intentional physical contact with the boys. So joining is okay, but to have physical contact, that one something which is beyond, okay, beyond the norm. It's not reasonable. The judge also said that there was no problem, okay, with the teacher taking part in the game. Yes, he might join the game, but the act of negligence, okay, the emphasis was that, okay, here he was negligent because there was intentional physical contact, tackle him. That's the intentional physical contact. That's why he was made liable. Okay, so he cannot really plead, or he cannot defend his case based on voluntary non-fit injury. Okay. So intentional physical contact was accepted as normal cause of events in rugby, but still did not prevent the teacher from being negligent. So in that particular situation, for that particular circumstance, okay, the teacher was was held for liable, okay, being held liable. Okay, let's have a look at another case here. This is one of the landmark case, common law, Wooldridge and Sumner, reported in 1963. And the rule which is applicable, okay, to this case is that a person attending a game or competition, he takes the risk of any damage, of any injury caused to him by any act of a participant done in the course of and for the purposes of the game or competition. So by being there, by participating, by watching there, okay, by being one of the spectators or audience, so he takes all the risks, okay, and that is notwithstanding that such an act may involve an error of judgment or lapse of skill on the part of the participant here, okay, unless, okay, meaning that here normally he cannot plead the defense of not voluntary non-fit injury unless the participant's conduct is such as to evince a reckless disregard for the spectators' safety. Unless, okay, the defendant can really show to the court that the participant was reckless, okay, in participating during the game or during the competition, for example. Okay, what happened in Wooldridge and Sumner here? Okay, the claimant was a photographer. Okay, but he's not a participant, he's not a spectator, he was a photographer, and he was working at a horse show. And when it happened, okay, he was situated within the ring. So there's a certain area, okay, within the ring, in the location, the area itself, where the horse show took place. And rather than behind the spectator barriers, meaning that there was a barrier. The ring is the barrier. It's supposed to be behind the barrier, but maybe he wanted to get the best angle or to shoot, okay, the picture. So he was standing there, okay. And when one of the horses galloped, okay, towards him at a significant speed, obviously, okay, after the rider lost control of it. So the horse knocked him down and he suffered injury. So now the photographer sued the defendant in the tort of negligence. So what's the issue here? Okay, the issue was whether the defense of voluntary non-fit injury could be made available or applicable in this case. Okay, meaning that because given that, okay, the claimant was within the ring, so that's the main issue. Okay, he was within the ring rather than behind the barrier. Okay, rather than behind the protective. He should be behind the protective barriers, but he voluntarily took the risk. Okay, assumption of the risk on his part here. So High Court held that the defendant was not liable. Here, claimant can still claim, all right? So the court held that in this case, the sportsman merely made an error of judgment, and the claimant actually here had chosen to position himself close enough to risk such errors affecting him. So he cannot claim for the injury that he has suffered. Okay, so no liability on the part of the defendant. So yes, defendant actually successfully pleaded the defense of voluntary non-fit injury. So it absolved defendant from the liability. Okay, that's the effect of this defense. It's a strong defense actually. Okay, let's have a look at another case here. Condon and, I'm not sure how to pronounce it. Okay, Condon, I think. Condon and Basie, 1985. So the claimant suffered a broken leg during a tackle. So it was another tackle. Just now we were discussing about rugby. Okay, now it's about football. Okay, he was injured. He suffered a broken leg during a tackle from the defendant in a football match. And claimant actually was playing for Whittle Wanderers, and the defendant was playing for Calso Football Club. And actually both clubs here is not the professional club. They are just the amateur, okay, amateur club league. So now the issues here is that what was the standard of care expected of a football player? Because the standard will determine, okay, whether they were reckless or not, they were complying with the rules or not. And this is the decision, okay, here. The standard of care varies according to the level of expertise the player has, obviously. So the standard for professional player is not the same like amateur player, okay? So, and then the court had found that the defendant was in breach of duty as the tackle was reckless. So tackle is something which is common, but it has to be done properly or reasonably. But in this case, the tackle was reckless. Even with regards to the standard of expected of a local league player, so basically, we cannot apply a voluntary non-fit injury here because why? Tackle was reckless. So they do not accept, I mean, the players here who was injured, they do not accept the risk of injury which occurs outside the rules of the game. So reckless tackle is actually outside the normal rules of the game. So substantial damages were awarded for injuries arising from a tackle, and the court did not accept the defense of voluntary non-fit injury. So defendant cannot escape from liability. Okay, that's the reason, okay, why the court didn't allow the plea of a voluntary non-fit injury. Okay, it was made in reckless and dangerous manner. Reckless plus dangerous, even though no malicious intention because they are playing, okay, they are in a game, right? But the way it was done is reckless. I mean, obviously reckless and very dangerous. So I mean that here it's possible that it might cause injury to the other party here. Okay. Okay, we are done with voluntary non-fit injury in sports cases. Now we want to focus on rescue cases. If you still remember when we discussed about nervous shock, okay, we also, discuss about, we are going to look at the same, the same case basically. Okay, one of the cases involving rescue. And when we talk about rescue cases, okay, the main focus is on the reasoning is public policy reason. So rescuer should be allowed to claim, okay, and this defense shouldn't be made available to the defendant. Rescuer is the claimant, okay, the plaintiff. So the claim shouldn't be precluded, okay, because of this voluntary non-fit injury. Okay, that's why for public policy reason, voluntary non-fit injury is not preferred by the court. For example, in the case of Chadwick and British Railway Board. And this is the quotation or observation by Professor Goodhart. So he's academic jurist and lawyer. Okay, and I put the keywords, okay, from his words here, his observation or his statement here. Okay, to rescue. All right. So American rule is that doctrine of assumption of risk does not apply. So meaning here, voluntary non-fit injury is not applicable to rescuer. To cases involving rescue. Okay. And we are going to discuss two important cases involving rescue. The first one in Haynes and Harwood, 1935. But and then similar facts but different observation. Okay, in an earlier case, Cutler and United Dairies, 1933. Let's have a look at the case. Before we go to the two cases, now we go to Chadwick and British Railway, reported in 1967. Okay, so Chadwick, this case arose from a horrific train crash, very terrible. Okay, it's like a tragedy in Lewisham, in which 90 people were killed. So a lot, okay, involved so many people, so many deaths here, and many more were seriously injured. So who was Chadwick here? Mr. Chadwick lived 200 yards from the scene, so it's quite near, okay, nearby of the crash, and he attended the scene to provide some assistance. So he became the rescuer. So meaning he's just it's not it's not the rescue team, but he assisted in the rescue work here. And then during the tragedy, okay, when he gave the assistance, he worked many hours, okay, through the night and crawling beneath the wreckage. Like this is the real picture when I Google, okay, crawling beneath the wreckage, bringing aid and comfort to the trapped victims. And as a result of what he had witnessed, he suffered acute anxiety neurosis. That's why we discussed the case under nervous shock. So the court held that defendant, okay, the one who was responsible for the accident, for the train crash here, owed Mr. Chadwick a duty of care, okay, since it was reasonably foreseeable that somebody might try to rescue the passengers and suffer injury in the process. So voluntary non-fit injury is not allowed, okay, to be raised or to be pleaded by the defendant, okay, in this particular case, because it involves rescue and it is for that policy reason, for public interest, okay. if we allow voluntary non-fatal injury to be pleaded, so it will actually discourage people to be the rescuer in other incident. Okay, because why? They cannot claim later if they suffer from the shock, for example. Okay, let's have a look at the two cases. Similar facts, but with different judgment. Okay, the case of Haynes and Harwood, 1936 here. Plaintiff was a police constable on duty, and he was actually located inside a police station in a busy street and often attended by many people, including children. So you can imagine, okay, in a busy street, public street. And who was defendant? Defendant, he was the owner. Okay, he owned a 2-horse van, like in the picture. Okay, those days, that's the main way, okay, of transportation. I mean, similar to our cars, okay, nowadays. So he left the 2-horse van here unattended by its driver in the same street. And the driver had put a chain on one of the wheels of the van that was subsequently broken. And for some reason, okay, supposedly because a stone was thrown at the horses, so the horses bolted. Okay, the horses ran away along the busy street alongside with the van. So it's like running. I mean, the horses run away with the van. Okay, pulling the van together. So plaintiff saw them, okay, because he's a police constable. So he saw this what happened here outside, okay, from the police station. So he got out quickly and he managed to stop them, the horses together with the van, okay? But he suffered from injuries. And now he claiming for damages, okay, for the injury that he has suffered. So what's the issue here? The issue is that does the maximum voluntary non-fatal injury prevent on-duty police officers from claiming damages for an injury sustained as a consequence of acting while being aware of the risk that this involves? Given that here, can we allow the claim for the police constable because he wanted to rescue, I mean to make the things right lah, okay, to prevent further injury to public, for example, okay, to the people nearby the area. But he know, okay, I mean it's very high risk to do such a thing, okay, to pacify or to stop the running horse, okay, together pulling away together with the van or the cart basically. So the court held that defendants, okay, the horse owner, okay, must or ought to have contemplated in his contemplation foreseeable, okay, that someone might attempt to stop the horses in order to prevent injury. And then we shouldn't allow the defense of voluntary non-fatal injury. Here, this defense, okay, this rule does not prevent the police constable from claiming damages for an injury sustained. Because why? He did not voluntarily agree to take the risk, but he did it, okay. His action here is pursuant to his official duty. He was aware of the risk, but it's not, I mean, he didn't give his consent, okay, to the injury that he has sustained. So meaning that here, voluntary non-fatal injury was not applicable. I mean, was not allowed to be pleaded. All right. Okay, compare with this case, Cutler and United Dairies, 1933. The claimant was injured, okay, when he entered a field to calm some horses. Meaning that here he was nearby and he saw the horses bolted. Okay, so he quickly entered the field to calm, okay, the horses, and he suffered injury. So now he wanted to claim for compensation, but his claim for compensation was unsuccessful. The court denied the claim because the horses presented no immediate danger to persons or property, and there was no need for him to intervene. So he was fully aware of the risk, and the moment he decided to calm the horses, the horses didn't pose any danger to anyone. The horses was on the field, so actually he was aware and he consented to the risk lah. Basically, this is the distinction between Cutler and United Dairies compared with Haynes and Harwood. Okay, so in this case, for Cutler case, voluntary non-fatal injury is applicable. I mean, was successfully raised, okay, pleaded by the defendant. So defendant can be absolved from liability to pay for damages. Okay, that's all for this second video of the recorded lecture for general defenses in torts. Okay, we are going to continue with third video for this particular topic. So I stop share. Okay, Assalamualaikum warahmatullahi wabarakatuh.